First things first, though, is I have Mr. White that's been representing him.
Right.
And I guess, did I grant your motion withdrawal or we're having a hearing now?
We come back on Monday.
All right, so come on up.
So Will reached out to me on Wednesday. I spoke with Michael on Friday. I spoke with Michael on Wednesday. And so basically the understanding is that Will's gonna sub in and take over and I guess possibly resolve the
hiring
case for
on?
today.
I'm hired on to this new felony
Okay.
case that triggered this whole deal. I've agreed to sub in on this case to work out whatever's going on here, and I've been talking to Michael about that. The felony case is bogus for a lot of reasons, but talk to the state about this.
Whoa, hold up, did you catch that? The defense attorney just called the felony charge bogus in open court. That's bold. But here's the kicker, judges don't care what you say is bogus, what matters is what you can prove. What do you think? Was that confidence or desperation?
This as well.
Well, hold on.
Okay.
Putting the cart ahead of the horse.
Okay.
So you went out.
Yes,
Okay.
sir.
You're out.
Okay. And I'm in.
Well, I don't know.
Okay.
You want me to appoint him a lawyer or do you want to?
I'm taking it pro bono because I'm hired on the felony and we want to just resolve this DWI deal today, probably.
Well, because here's the deal. I'm putting him in jail. You picked up a felony while you're on bond for a DWI. You're not supposed to pick up any new cases. You've now picked up a felony, an injury to a child, and it's just now coming to my attention, even though this thing's from November. I'm revoking your bond. Goes with you.
Which one's that? Okay.
Let's talk.
May I be excused, Your Honor?
Please.
Thank you.
Thank you, Mr. White. You did file a motion to withdraw, correct?
I didn't.
Mr. White?
He didn't file it.
Aaron,
I thought you
did you file a motion to withdraw?
Yes, I filed it last week.
Yeah, I saw it.
I don't have one. Yeah.
It's on Douglas.
I just see an appointment form from January.
I see the motion to withdraw. Yeah, it's there. Do you see it, Seth? Do you need a cost number?
I have the 2500939. Oh, no. Okay.
Yeah, can you put it in the queue so I can sign it? Okay, all right. Tell me.
I know.
Okay, there's a certain standard.
I
You pick
understand.
up an injury to a child. I don't know anything about the case. All I know, he's picked up a third degree felony, and it's a serious charge. It's not like it's a
Yeah.
trespass, but it's so.
But you know that these charges can be empty.
But I don't know that for sure. All I know is that he's picked up a felony. He's not done squat while he's on bond for this thing. He's literally been riding free, not doing anything for the last 4 months, 4.5 months.
Has he been blown in?
Nothing.
Nothing?
Done nothing. He's not tested. He's not had. He's literally done nothing. So, anyways,
State's offered a time served. I talked to Michael about it. I'm like, hey, my plan coming in was to try to get him back on PTI because
they're like,
the felony is so ridiculous. It blows my mind. But regardless, I was talking about that this morning. He's like, honestly, Will, he's like, the PTI it's not feasible for me to do. He's like, is there any other alternative?
if you want time, take it maybe a day.
I don't need the time. He wants to time serve it today, Judge.
Well, if that's what he wants to do, then that's on him.
Okay. Would the court accept that?
Yeah,
Okay.
absolutely. I mean, look, far be it from me to, because that's what we would do in every case.
Right.
Any case that comes back here. And I mean, obviously, state, you need to also be happy as well, right?
Yes, Your Honor.
But it's on you guys. So I'm on board if they're on board.
Okay. I will run it by him just to make sure and then we'll get paperwork started. Thank you, Judge.
Mr. Douglas, you're charged with driving while intoxicated. First offense, it's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. You know, it doesn't make me happy to put people in jail, but if you're a danger to my community, I only have one place for you. Do you understand?
Yes, sir.
You need to understand something very serious now, that this DWI is going to go on your record. It'll be there for the rest of your life. It's even there after you die. You get pulled over again, first thing an officer does, they're going to look at your record. When they see this and they look at the other, what do you think they're going to do? Think they're going to be happy? Think they're going to give you a hard time? Probably. So if you even have the most faintest remote smell of anything funky, it's probably not going to go well for you. You need to understand that from now on, it's a minimum of 90 days in jail. Do you understand?
Understood.
You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, it will go on your record. You can never take it off. Do you understand? You still want to do this? How do you plead to the offense of driving while intoxicated? Guilty or not guilty?
Guilty.
Is it true or untrue that you had a .15 or above? Okay, so true to the enhancement. You need to understand one more thing, Mr. Douglas, is that we all make mistakes, right? Everyone's human. But when you continue to endanger other people's lives, there are no more mistakes, they're actions. And when you keep making boneheaded actions, we have longer sentences, bigger jails, more fines. This carries a fine of $4,500. And if you don't do it, you sit in jail 1 day for every $100 you owe. So you can imagine how much jail time you will do on a $4,500 sentence. On a second DWI, it's a $6,000 surcharge. Get a clue. If you want to get lit, great. Take an Uber. $40. Anywhere you want to go in this city. You understand?
So,
What do you do for a living?
work at a warehouse.
How much money do you make a month?
I'm sorry. 16.
Look, I'm going to waive your fee for you today. You come back with another DWI, get ready, because it's just, do you understand? Get a clue. Good luck. Oh, I am suspending your license for 180 days, sir. Do not drive until you get a license. All right, sir. Good luck.
Thank you, Judge.
Thanks. Good morning, Ms. Howard. So you were wanted out from another state. Your lawyer is asking me to set you a bond. I don't know. You know, I've never met you before. I don't know you. I don't know how dangerous of a person you are. I don't know if I give you a bond, are you going to go back? I don't know.
Listen to that, gumdrops and rainbows. The judge is basically saying, talk is cheap, your record speaks louder. And Miss Howard's record? Let's just say it reads like a true crime novel. Question for you, if you were the judge, would you even consider giving her bond here, or is that way too risky?
I know that you're going to tell me it's little gumdrops and rainbows, but how you are on paper tells me who you are, because everybody tells me one thing, but when they get on paper, they're a completely different person. So I got to get to know you before we set you a bond. So Amy, tell us about Miss Howard.
Yes, Judge. She's wanted from Navajo County, Nebraska, for burglary, felony 2A, theft of lawful taking 5,000 plus, and conspiracy to commit a class 2A. State is opposed to a bond based, one, on the charges that she's wanted for, two, on the fact that she has previously been a fugitive in your court.
Oh, really?
Yes, from South Carolina for robbery.
What happened with that case? Do you know?
I believe they picked her up in that case. Yes, they picked her up in that case. Her most recent conviction was also back in 2024 for a beating with a motor vehicle out of Fulton County. Day has also indicated to me that she is on federal probation right now.
She's on. That's out of Arkansas, Judge. That's what she's on bond for. She is on the leg, has the leg monitor on for that.
What's she on federal probation for?
What are you on probation out for?
I think like a drug conspiracy charge.
Where?
A conspiracy?
Out of where?
Arkansas.
That's the case out of Arkansas, Judge.
Possession with intent to distribute, it looks like. Her release date is 2020.
So is that different from what she has in Nebraska, the federal probation case, or are you talking about, is that the same one?
Nebraska should be different. What she's wanted for right now is the burglary. So the basis of the probation, the federal probation would be the possession with intent to distribute.
Got it.
That's out of Arkansas. When she was in Arkansas, Nebraska put a hold on her, but they didn't come get her.
So let's get this right. Here in Harris County, in 22, you have a burglary of a building, a failure to identify oneself as a fugitive from justice, meaning you're trying to evade law enforcement. You have a prior fugitive case from 21. You have another failure to ID from 2024. You're on federal probation in some other state. You have another open burglary in Nebraska, and you had an evading in a motor vehicle in Montgomery County. And you want me to set you a bond?
That's all right.
Should I? Really?
Ms. Howard, how long have you been in Houston? How long have you lived in Houston?
All my life.
Okay. You currently were on a probation and you have a leg monitor pursuant to that, correct?
Right.
Okay. And you had a leg monitor on you when they pulled you over, is that correct?
Right.
Okay. Did you attempt to flee from at that time?
No.
Okay. And that's what, you're aware of that case up in Nebraska?
Not until my lawyer had told me to turn myself in, but they said when we were a court date for that.
I don't want you to talk about the cases now.
Okay.
How old are you, ma'am? How old are you?
24.
You're 24 and you have all those priors. You scare me, Miss Howard. You truly do. Because if I put my name on a bond, I don't want something bad to happen. And as history dictates, and as the paper says, it's, sometimes we have to protect people from themselves because they're their own worst enemy. You know, you scare me. I can't give you a bond. It's hopscotch with states with the criminality. It can't just happen. And you have a prior one from here as well. I just can't do it, man. It just, at some point, it comes time, the bill comes due. That's now.
You already executed a waiver, Judge.
Okay, all right. Thank you, Ms. Howard. Each of you are charged with assault causing bodily injury. You are each facing a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On February 23rd, 2025, an officer responded to the parking lot of the Bell Rock Market Station in Harris County, Texas. The officer was advised by dispatch that there were multiple subjects physically fighting and that a female was being dragged across the ground. Upon arrival, the officer saw that 2 females and 1 male had been detained and they were put in separate patrol vehicles. The female that was assaulted, the complainant, was placed in the back of an ambulance. Defendant 1, ID'd as Nancy Flores Gemberling. Defendant 2 was identified as Bruce Gemberling. Defendant 3 was identified as Jasmine Brianna Cole by their Texas driver's license. The officer made contact with the complainant, who advised she had come to the location to deliver food to a customer because she was working a food delivery service. The complainant parked next to another vehicle and started to get the groceries out of the back of her vehicle. And the complainant noticed defendant 1 and defendant 2 staring at her inside the vehicle next to her. The complainant thought it was odd, but continued to grab the groceries. She went to the staircase and defendant 1 rolled down her window and advised the complainant that where she parked was not a parking spot. The complainant responded asking if they were security and continued to make her way to the delivery. The complainant was on her way back and she observed defendant 1 and defendant 2 at the bottom of the staircase, and there were more people with them. The complainant stated that defendant 1 was talking trash toward her when she got to the bottom of the stairs. Defendant 1 then got in the complainant's face and did a push and shove where the defendant jabbed her hand at the complainant and it pushed the complainant back. The complainant stated she then put her arm up towards defendant 1 and then she advised she started getting physically struck on both sides of her head multiple times. The complainant advised that she was able to grab a hold of defendant 1's hair. The complainant stated at some point they ended up on the ground and someone was holding her head down. She stated she was eventually able to look up and saw that defendant 2 was holding her head down and he kicked her. The officer watched a video
that was taken up the incident, and it showed the complainant getting off the ground, then the complainant and the first defendant fighting each other. It was shown that a male had stepped in and broke them apart. The officer observed the complainant to have visible injuries. The complainant was bleeding from her left eye and had lacerations to her eyelid and had active bleeding and swelling around her left ear. The complainant stated she felt pain and discomfort. The officer spoke to defendant 1, who stated they were waiting for their family members in the car when the complainant came and parked close to the front of their vehicle. The defendant 1 and defendant 2 were wondering who the complainant was because the garage next to theirs was vacant. And defendant 1 advised that she told the complainant that where she parked was not a parking spot. And the complainant responded saying that she did not give a fuck and threatened to call ICE and called defendant 1 racial slurs. Defendant 1 was not sure what racial slurs were said exactly. Defendant 1 advised the complainant threatened to slap the shit out of her with a water bottle. Defendant 1 stated that she would call the cops. Defendant 1 stated that her and defendant 2 waited at the bottom of the staircase for their family members. When the complainant came downstairs, the complainant stated that she was going to beat the fuck out of her. The defendant stated she was struck by the complainant and did not know how, and they ended up on the ground and did not know how, and defendant 1 did not remember much. The defendant's son came in and separated her and the complainant. The officer also spoke to defendant 2, who has read his Miranda rights and did not want to provide a statement. The officer spoke to defendant 3 and read her Miranda rights, and she said she would. Yes, Judge. And she said she would give a statement. Defendant 3 stated she was getting ready to go meet defendant 1 and defendant 2 when she came downstairs, and defendant 1 had told defendant 3 about the complainant. Defendant 3 went back upstairs to grab some things, and when defendant 3 was on her way back down, she heard the complainant saying racial slurs to defendant 1. While at the bottom of the stairs, defendant 3 saw defendant 1 and the complainant to be face to face. Defendant 3 stated the complainant struck defendant 1 and they started fighting.
Hold up, so this whole fight started because of a parking spot while a DoorDash driver was just trying to drop off groceries? That escalated way too fast. Honestly, this feels less like a court case and more like a reality TV episode. Question is, are parking disputes really worth felony charges?
And ended up on the ground. Defendant 3 advised she kicked the complainant in order to get her off of defendant 1.
Yeah. I'm gonna find it. So you did say that 3, Ms. Cole.
She admitted to kicking the
Guys, I'm going to find that there's sufficient probable cause to go forward with each of your cases. I'm now ordering you as a condition of your bond not to have any contact with the complaining witness in this case and not to go back to this location. Do each of you understand?
We live at the location.
They live at the location.
What is
it? It was a DoorDasher and she was dropping off groceries.
So she was just dropping off groceries to them.
Not to them. She was dropping off groceries to another resident at the complex.
I see. Okay, so that was, got it. Okay. So like I said, I am going to find that there's probable cause to go forward with your case. I'm not going to prevent you from going back to this location, but I am ordering you not to have any contact with the complaining witness and not to be in possession of any weapons. If I find that you're a danger to my community, if I find that you pick up any new cases, you get into fights with anyone else, you lay your hands on anyone else, I will lay my hands on your bonds, throw them in the air, and put you in jail. Do you understand? I will protect my community at all costs. I don't care who comes. I don't care where they park. I don't care what your excuse is. It doesn't matter to me. Do each of you understand? Do you understand, sir?
Yes.
So do you mind filing no contact with the complaining witness? No weapons?
Yes, Judge.
Do each of you have the ability to hire a lawyer? Okay, we will give you each time to go hire a lawyer. So we're going to reset your cases, give you time. When you come back, please have a lawyer. For now, I will have you sign, each of you have to sign a reset with Victoria. I will have you take a seat in the jury box while they get your bond conditions. We'll have you sign, and after that, you'll be free to go. Keep my county safe. Do you understand? I don't want any more danger. I have only one place for people who are dangerous in my book. Do you understand? We will not get any more warnings. Come on. You are Noe Lopez.
Yes, sir.
Mr. Lopez, you're charged with 2 cases. You're charged with harassment. You're also charged with criminal mischief. On both of those cases, you were facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On February 23rd, 2025, an officer was dispatched to a disturbance family call at a residence in Harris County, Texas. The officer made contact with the defendant and the complainant. The complainant stated the defendant, her ex-boyfriend, had been causing a disturbance at the residence. The complainant stated the defendant moved out after breaking up with her and began to contact her again via text messages. The defendant then came over to the residence uninvited that morning. The complainant believed the defendant was intoxicated. The defendant banged on doors and windows all around the residence, scaring her and her children. The complainant stated the defendant left prior to the officer's arrival. The complainant, after the officer left, the complainant had to run errands and got in a pickup truck and noticed the right rear window had been smashed. The complainant believed the defendant may have used a brick to break the window. The complainant found a brick on the bed of a truck near the window. The defendant returned uninvited in the afternoon and once again started banging on the resident's door and windows trying to come inside. The defendant advised he was trying to remove some of his property that broke the complainant's truck window earlier because the complainant was having a hassle with him. The defendant stated he did not use a brick to break the window, instead he used something else. The defendant later stated he no longer had any property there and he wished he never left his own residence. The complainant also advised the defendant had been continuously messaging her via text even after she informed the defendant she no longer wanted anything to do with him. The officer observed several only incoming text messages from the defendant, approximately over 40 text messages, 2 audio messages, and a photo message within 2 days. The cost of the window was approximately $200.
Okay. Mr. Lopez, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, then I will revoke your bond and put you in jail. Do you understand?
Yes, sir.
I'm also ordering you not to have any contact with this person and not to be in possession of weapons, not to go within 1,000 feet of where she lives, where she works.
Sir.
You understand?
Yes, sir.
If I find that you go anywhere near this person is obviously afraid, I don't want you to accidentally bump into her. So I don't want you to go anywhere where she lives or where she works. If I find that you do, likewise into jail you will go. No more PR bonds. Do you understand?
Yes, sir.
So would you mind reaching out to the complaining witness to let her know that we've entered this order for
Yes,
a
sir.
radius so that if Pete should try to have any kind of contact with her via messages, cell phone, anyway, to let us know.
Yes, sir.
Mr. Lopez, would you like to apply for a court-appointed lawyer?
Yes, sir.
Okay. I already have an affidavit, Deputy Miranda. So for now, what I'm going to have you do is I'm going to have you go to Victoria, sign a reset. You will get with Felicia for your bond conditions, and then I'll have you take your seat in the jury box while I find your lawyer.
Thank you,
Okay?
sir.